Drama in the case of Sean Diddy Combs continues as the defense accuses the government of misconduct and prosecutors respond that the defense is keeping them from doing their job. We're going to analyze the latest flurry of legal filings with Palm Beach County State Attorney Dave Aronberg. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey, so before we jump into this, I have an exciting announcement I got to tell you about first. The video version of Sidebar is now available on Spotify. That's right. We are so thankful for you guys, your support of Sidebar. Us getting this show on Spotify video truly is due to how loyal this audience is. So thank you so much. And yes, you can now watch and listen on the go. From Diddy to the United Healthcare CEO shooting to crazy court moments, it is all on Spotify now. So you can scan the QR code on screen or click the link in the description to follow Sidebar on Spotify. As disgraced rapper Sean Combs, known worldwide as Diddy, prepares to spend Christmas behind bars in New York, his first Christmas behind bars in New York, his legal team is very hard at work, and they are writing up briefs and motions that they're filing with the court in the Southern District of New York, because that's where Combs faces federal charges of racketeering conspiracy, sex trafficking through force, fraud, or coercion, transportation to engage in prostitution, and remember, investigators allege that Combs was using his power, his wealth, his influence to force people to participate in so-called freak-offs, these prolonged sex orgies that sometimes involve drugs and commercial sex workers. My gosh, how many times I've said freak-offs in the past 3 months is pretty unbelievable, but again, that's where we are. So anyway, there we have the criminal charges, but we also can't forget the civil lawsuits. They continue to pour in against Combs, and new witnesses also reportedly are testifying before the grand jury in the criminal case. So we're waiting to see, one of the things we're waiting to see is if the government will file a superseding indictment, adding or amending those federal charges, possibly, maybe even adding defendants too. We'll see. Now, to be clear, and it's always important to emphasize this, Combs has not only denied all wrongdoing, but he has not been found guilty of any sex crime or found liable in any of these civil suits. You know, I say he's denied all wrongdoing, but he did essentially admit to his actions on that 2016 surveillance tape of him beating his ex-girlfriend Cassandra Ventura in a hotel hallway. Even his mother, in a legal statement, seemed to acknowledge that was him. But putting that to the side, the rapper was arrested outside of his hotel in New York City back in September. And his attorneys say, look, he had planned to turn himself in, but agents arrived a day early to take him into custody. He's been at the Metropolitan Detention Center ever since. And his attorneys have argued from really the very beginning several times that the steps taken by the prosecution are not only wrong, but they say they're unconstitutional. They want this case thrown out. What we want to do right now is get into the latest battle over what's called a filter team or taint team. Now, Combs' counsel says that the group, which is supposed to help protect Combs and keep the prosecution from seeing privileged information, isn't doing its job. So what is a filter team? Why are they controversial? Well, I'm not going to talk about this by myself. I have somebody to help me answer that. Going to break down what is going on here between the prosecution and the defense. So to join me to talk about this, I want to bring back on State Attorney for Palm Beach County, Florida, Dave Aronberg is back with us. Dave, good to see you.
Jesse, great to be with you.
What is a filter team, Dave?
Remember when the feds raided Rudy Giuliani's house? Remember that? Giuliani's a lawyer, and so you can't go into attorney-client privilege. So how do the feds know the difference between what they're allowed to see and what they're not allowed to see? What is privileged and what is not?
And privileged, you mean private communications between his attorneys or things that are done in anticipation of the trial, right? Work product.
Correct. See, prosecutors aren't allowed to see everything. There are limits. Yep. And you have the Constitution, that pesky thing called the Constitution. There's the Fourth Amendment. You've got attorney-client privilege and all these other privileges, executive privilege. So to prevent the prosecutors from being tainted with information they're not allowed to see, they have what's called a taint team.
These are prosecutors?
Yeah, people from within the Department of Justice. They have special prosecutors. And because the word taint team was kind of unseemly and ugly, they decided to change it to filter team. So now we call it the filter team. And that's all it is. It's just the people who stand between the actual prosecutors on the case and the defendant.
And they are not part of the case at all. They're not prosecuting Sean Combs. They are separate, independent. That's what they're supposed to be.
Correct.
Okay. All right. So with that in mind, Combs' defense team, they have raised serious concerns about this filter team before. And it was mostly in connection with photographs of notes that were taken from Sean Combs' cell or his unit at the Metropolitan Detention Center in Brooklyn. which the defense says were protected under attorney-client privilege. So back in October, there was a federal raid at the MDC. It reportedly had nothing to do with Combs being there, this is according to officials, but it was pre-planned. It seems Combs' defense lawyers would disagree. They said this is really just a pretext. But as part of that sweep, Combs was questioned and photographs were taken of items that were found in his unit as part of this search for contraband. And we told you before, the MDC is just notorious for drugs, weapons, all sorts of violence and misconduct. But according to prosecutors, an investigator at the Bureau of Prisons let prosecutors know that the photos were taken of Sean Combs' writings, these notes, these potential communications. So to be on the safe side, prosecutors say they had the photos go through the filter team first. And some of the photos were sent back to the government, who apparently used them as evidence as part of their opposition to Sean Combs getting bail. What evidence? Well, in one of their filings in support of keeping Combs behind bars, the government wrote, "The government argued that the defendant was actively continuing his efforts to obstruct justice while in custody, including by, among other things, attempting to influence witness testimony. In support, the government cited excerpts of portions of the photographs that discussed the defendant paying a potential witness and on other potential victims and witnesses, which had been provided to the government after review by the government's filter team." So the defense argued that the notebooks had the word legal written across the top, indicating, they were privileged, they shouldn't be looked through, they shouldn't be photographed. But that led to a hiccup because the judge wanted to know exactly when legal was written on one or several of these notebooks. And he also wanted to know if the defense was maybe trying to mislead the court on this issue, even call the defense out for maybe not being entirely accurate with when it was labeled or what was labeled. But in the end, Judge Arun Subramanian, the judge overseeing this case, did order the prosecution to get rid of copies of 19 pages of material and said that they couldn't use it as evidence in their motion to deny bail at this upcoming bail hearing. And by the way, that bail hearing ended with Sean Combs being denied bail a third time. But the judge did set a schedule for briefing and arguing about whether the photographs were a violation of Sean Combs' rights and what would the remedy be. Now, the defense is very unhappy with how the prosecutors and filter team are currently handling things, and they filed a motion for a hearing, suppression, and other relief. And according to that filing, the defense claims that the prosecution bypassed protocol that was in place for what to do if they received privileged information, and instead the filter team just gave mostly everything over to the government. In their filing, the defense gave several examples of cases from around the country where the validity of a filter team has been questioned, some dating back to 1994, others as recent as 2022. And the defense writes, "The cases above recognize that in general, the use of a neutral arbiter, such as a special master, is more likely to protect a defendant's rights than the use of a prosecutorial taint team. And whatever the general merits of the taint team procedure, the filter team in this case utterly failed. Despite seeing references to defense experts, paralegals, witnesses, cross-examination strategy, and even names of defense lawyers, it failed to mark the material as privileged." They go on to say this extraordinary violation of Mr. Combs' Fourth and Sixth Amendment rights also constitutes outrageous government conduct that violates his Fifth Amendment right to due process. These are serious allegations. What do you make of it?
Well, I disagree with the defense lawyers that this is outrageous political or prosecutorial conduct, because the prosecutors have been doing this type of thing for years. Remember, this was the argument that the defense is making that Donald Trump made in the Mar-a-Lago documents case, that before prosecutors should ever look at anything retrieved, we need to go to a special master first. That's what Judge Cannon
What's a special master?
It's like a judge, a magistrate who will review the documents. This is what the defense here wants. They don't want the prosecutors to say. They essentially say that the taint team is tainted, because how do you have a neutral set of prosecutors when you work for the Department of Justice? Your colleagues are the prosecutors, but that happens all the time. And when Donald Trump and Judge Cannon tried to make this argument, they lost, because the appellate court said, no. It is fine for the filter team to do this because they're not involved in the case. Also, prosecutors take an oath. If they find exculpatory evidence, meaning evidence that could clear someone, they have to turn it over. It's different than a defense lawyer who's purely seeking the interests of the defendant.
But their argument would be these are materials that are clearly attorney-client or work product privilege, and it was handed over to the prosecutors improperly. And look what the judge said. The judge said, delete, get rid of the 19 pages of copies you have. So, I mean, again, talk to me about, do they have an argument here, the defense? And B, what rights does he have while in detention? He talks about his due process rights. I mean, also, I believe his rights to reasonable search and seizures, a Sixth Amendment right. Talk to us about what rights he has while being detained, and also, does he have an argument here?
Well, this whole situation shows that the process works. It works because the filter team reviewed it. The filter team made a determination that these were not covered by attorney-client privilege, pass it on, and then the judge said, no, I disagree. We're going to throw it all out. And the prosecutors were not able to use that. The system works. No one is perfect. This is a judgment call. But also, I think it is kind of interesting that the judge sort of shared my suspicions that it looks like Diddy wrote the term legal on everything.
Well, we don't know if it was him or someone else. Or, yeah.
But, just by putting the term legal doesn't make it privilege. It's not like you can say Beetlejuice and all of a sudden everything disappears, because here it looks like a lot of the stuff was not really privilege, was evidence of witness tampering. But they got away with it because they put the term legal, and the judge said, we're going to err on the side of protecting the defendant, which is why, to your last question, the system is working because the defendant continues to have protection. Sixth Amendment right to a fair trial, to right to a lawyer, the Fourth Amendment right to unreasonable searches and seizures. You have all these protections, attorney-client privilege. And so the judge here is recognizing that and protecting Diddy's rights. And so I think the system worked.
Is there a scenario where an indictment can be thrown out because of serious violations of privilege or constitutional rights? Because that's what they're asking for.
Well,
one of the things they're asking for.
That's why they're saying this is outrageous conduct by the prosecutors. If this was an innocent mistake, then no, it would not be thrown out. If it was intentional misconduct, then yes, that could happen. That could be the penalty. That's what they're going for. But there's no evidence there is intentional misconduct. They went through the proper process that's used in every case where you have this filter team. The filter team says this is privilege, this is not. And if the judge disagrees, the judge throws it out. That's exactly what happened here.
They're also asking, I think, for a minimum to look into this filter team, also look into the prosecutors, and maybe possibly disqualify any of the prosecutors who were involved in this. And the way I think you would look at that is to say, A, if they engaged in wrongdoing, they shouldn't be part of the prosecution. But B, if they've already viewed what was privileged and work product, if they've already viewed privileged material, they shouldn't prosecute this case. That's not fair to Sean Combs. What would your argument be to that?
Depends how damaging the privileged material is. If it's because the filter team gave them something that they're not allowed to see, and it only pertains to the question of pretrial release, well, that doesn't go to the ultimate issue of the case. That should not disqualify the prosecutors. If the prosecutors saw something that they should not see as to whether Sean Diddy Combs is guilty or not, then perhaps that is an argument that that prosecutor should be removed from the case. But there's no evidence of that here. There's no evidence of intentional wrongdoing. What you're seeing is very well-paid, very aggressive defense lawyers doing their jobs for their high-profile, wealthy client.
And by the way, as an aside, let me also say real quick, it's not just us here at Law&Crime that have been covering these Diddy stories and updates for you. Websites all over the internet are grabbing readers with headlines like, Puff Daddy stays in jail for trying to influence witnesses. Woman sues Sean Combs for raping her. And that is exactly where a platform like Ground News comes in. So what they are is a small independent team that we actually partner with because they can help us deliver just the facts when we report on stories like this. You can go to ground.news/sidebar to follow along while I show you how it works with this Diddy story. So we get a quick summary of how Diddy's lawyers claim prosecutors allegedly unlawfully obtained his jail cell notes, including attorney-client privileged information. Remember that? Well, based on every source that Ground News found on reporting on this, the left are clearly dominating coverage, making this a potential blind spot for more conservative news consumers. But it's not just about who's covering the story, it's also about how they're covering it. Well, Ground News calculated the majority of these articles come from highly credible sources, so you can instantly see which headlines are more objective and which might be skewing the facts. The bottom line here, don't let someone else's spin shape your understanding of the truth. Just head to ground.news/sidebar or scan the QR code right there and use our link to save 50% off of the top tier Vantage plan, which offers unlimited access. It's the same plan that we've been using. So thank you to Ground News for sponsoring this episode of Sidebar. So going back to this motion for a hearing, at the conclusion of it, the defense listed out steps that it thinks should be taken, directing that a special special master, like we talked about, a judge, conduct privilege review in lieu of the filter team going forward. Now, after the defense filed this motion, the government responded, and they requested more time to essentially get their ducks in a row and file a full response. So this filing from December 5th reads, the government respectfully submits this letter motion to request an adjournment of the briefing schedule in connection with the motion filed by the defendant last night. Now, obviously, the court set a schedule for filings related to these notes. I mentioned about whether there was a violation regarding these notes that were photographed at the MDC, and that meant that the government's opposition paper was due December 9th. The prosecution's arguing they need more time than that, at least as much time as the defense had to file their own motion. So the government offered their own proposed timeline, which would give them until December 20th. The prosecution said that in their request, they needed to adequately respond to the myriad issues raised in the defendant's brief. Specifically, given that the government's case team cannot respond to certain arguments advanced in the defendant's brief regarding privilege because the case team is no longer in possession of the notes at issue, the government must add an assistant United States attorney to the filter team to take on that response. Additionally, given the breadth and scope of the extraordinary relief requested by the defendant, an adjournment is appropriate. The judge apparently granted that motion. Dave, what do you think?
Well, I understand. I mean, the prosecution is entitled to time to respond to these allegations. When the defense is trying to bounce these prosecutors off the case entirely, they want us to take a step back and say, all right, let's talk about this, especially because they do not have access to the materials in question. So the defense is saying you should never have seen this. Look what's here. And the prosecutor is saying, we don't have it. A lot of this stuff was in the possession of the filter team. Other stuff we had, and then the court took it away. So to give us more time, we need more personnel, and we need to fully brief this issue.
Long term, if the judge says something was really wrong here, at the very least, could that evidence not come in to trial? Could it be suppressed? If it's evidence of obstruction, him attempting to reach out to people, that would be really good for the prosecution's case, because obstruction is one of the underlying crimes of the racketeering conspiracy case, the criminal enterprise. You think there's a chance that evidence won't be allowed in?
It depends on whether there was prosecutorial misconduct. If there was misconduct, if it was bad faith, then yes, but there's no evidence of that. Remember the Lori Vallow Daybell case in Idaho?
No, I don't remember it.
Yes, the cult mob.
I lived 2 years of that case.
Right?
Yeah, 3 years.
The court took the death penalty off the table. Why? Not because of anything she did or said.
No.
It's because the prosecutors were slow in turning over discovery. So there are sanctions that courts can use to punish prosecutors. Now, if the prosecutors here were extra slow, no evidence of that, or extra dirty, no evidence of that, then yeah, you could have things like evidence suppressed or charges thrown out. I don't think that's going to happen.
I want to ask you about this. So let me take everybody to December 10th. So this is 10 days before the new due date for the government's response. The court receives a letter from 2 assistant U.S. attorneys who recently joined the filter team to help expedite these reviews. And those 2 AUSAs said that they're just trying to do their jobs, but they claim, and the prosecution claims, that the defense is basically stonewalling. So the filter team in this paper writes, in order to address this issue, the government asked the defendant to produce directly to the filter team unredacted copies of materials the defendant had filed ex parte with the court containing facts or analysis relevant to the defendant's privilege claims. And ex parte means that it was filed by one side without notice or input from the other side. Do it for, security reasons, safety reasons, privacy reasons. Anyway, this writing goes on to say, the filter team understands from its conversations with the defense that the defense refuses to provide fully unredacted copies of the ex parte filings to the filter team because doing so would reveal additional attorney-client communications and or work product beyond what is reflected in the notes. The extensive redactions and the copies of the Garagos declarations the government has received, however, make it impossible to fully understand the basis for the defendant's claims of privilege as to each of the challenged portions of the notes, and thus to evaluate and adequately respond to the defendant's claims. So when the filter team talks about redactions, this is what we mean. Huge chunks of the declaration from defense attorney Tenny Garagos, they are blacked out. There's really nothing meaningful there. For example, one section reads, next he wrote, then it's blanked out. Then Mr. Combs notes there are blank to his counsel as to blank. There's another page that's almost entirely blacked out with the only readable words being, however, Mr. Combs has communicated to me several times. Now, the government writes, in the event the court would like the filter team to address the privilege issues, The filter team respectfully requests that the court order the defendant to provide unredacted copies of the ex parte filings directly to the filter team. This is the part I'm not sure I understand. So what they're saying is, if you say there is a privilege issue, we, the filter team, need to see these actual documents. But doesn't that defeat the purpose? They don't have a right to see his privileged materials. What am I not getting?
It's the filter team, not the prosecutors on the case. So the filter team should have access to it, especially if you're claiming there was prosecutorial misconduct. Remember, there are 11 serious allegations against the Department of Justice, and they're trying to get the prosecutors bounced from this case. In the meantime, they're forcing these same prosecutors to respond, to fight with one hand tied behind their backs. They're saying, here, you have seen things you should not have seen. Meanwhile, they're not even telling the court what it is. And we're not saying that they should show the prosecutors that, just show the filter team, who are separate from the prosecutors. There's a wall between them and the prosecutors on this case.
So the defense responded, and they objected to the unredacted paperwork being given to the filter team. And they point out in their filing, the government cites no authority supporting any such request. So the defense gave its own example, this United States v. Battaglia case, which was argued in the Southern District of New York in 2015. And it says there, privileged documents were shared with a Wall AUSA pursuant to an agreement between the government and, I think that it said, the defendant. And when the Wall AUSA sought the disclosure of additional documents over the defendant's objections, the court denied the government's request and ordered the defendant to produce the documents directly to the court for an in-camera review. So, Dave, that means, and you tell me if that's a possibility here, all this back and forth, give it to Judge Subramanian. He'll determine if there's actually a privilege violation. And by the way, in camera means not in front of a camera. It means in his chambers, private, right? So is that an option?
Yeah, that's an option. But then how can the prosecutors ever be thrown off the case when the defense doesn't show the filter team any of the information they say was wrongly shown to the prosecutors?
Show it to the judge.
Show it to the judge, and then the judge says, yeah, the filter team should see it, though. Why wouldn't the filter team see it? Like, what's the problem unless you don't trust the filter team?
Well, that's what they're saying. They're saying
it, right?
They're saying the filter team failed.
Well, the thing is that I understand the case they're citing, but what they're doing is redacting pretty much everything. Like we don't know in the case they cited how much of this good stuff was redacted. It could have been just a little bit here and there. But what the defense is doing, they're trying to have it both ways. They're saying this stuff is so inflammatory. This is going to kill our case. It should be a mistrial. These guys should be thrown off the case. But we're not going to tell the prosecutors what it is. We're not even going to tell the filter team what it is. At most, we'll tell the judge what it is. And then the judge will then say, okay, I agree. Or how do the prosecutors respond to that? What kind of defense can they make to the argument unless they have access, at least their filter team, to the material itself?
By the way, really simplistic question before I let you go. Does the judge review it himself? He's got court clerks. Can the court clerks review privileged material, or that's not right either?
Sure. Well, the judge depends on his clerks. So, they can all do it.
Okay.
Also, there's a lot of material. The judge doesn't have that much
That's
time.
what I'm wondering. One person as opposed to a filter team. You're giving it to a judge to make the decision. That seems practically like it wouldn't make sense.
Yeah, it takes time, and these judges, they got other things to do. They got a golf game.
Wow. Wow, this is a big case for Judge Arun Subramanian, and we will continue to follow it. This is just kind of a tangential issue, but the back and forth between the prosecution and defense attorneys continue. Dave Aronberg, great seeing you. Thanks so much for coming on.
Thanks, Jesse.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.